Good morning. My name is Chris Williams, and I'm the chair of the Studies and Analysis Center within the National Security Space Association. We welcome you today to our latest edition of Space Time, today with Robert Metzger. I'll introduce Bob shortly here. The National Security Space Association is a 501c3 nonprofit support association dedicated solely to the national security space enterprise. We work to foster long-term cooperation among industry and government, leading the way with expert opinion, insight, and analysis. Let me take a moment to introduce our distinguished interviewee today. Robert Metzger heads the Washington, D.C. office of Rogers Joseph O'Donnell, PC. He co-chairs the firm's Cybersecurity and Privacy Practice Group and is a member of the Government Contracts Practice Group there. His practice includes cyber and related national security matters in addition to a wide range of public procurement and regulatory matters. In his litigation practice, he's counsel of record for Microsoft Corporation in the Court of Federal Claims litigation brought by Amazon Web Services, protesting the $10 billion DoD award of the JEDI Cloud Services contract to Microsoft. He's represented other class-leading international technology firms in a variety of administrative controversies as well as state and federal litigation. He has advised U.S. aerospace and defense and international technology companies on export control laws, on CFIUS and FIRMA, and on sanctions issues as well. As a special government employee of the Department of Defense, Bob was a member of the Defense Science Board task force that produced the Cyber Supply Chain Report in 2017, a highly influential report. Bob also is co-author of a publication entitled Deliver Uncompromised, a Strategy for Supply Chain Security and Resilience in Response to the Changing Character of War, that was released by the MITRE Corporation in August of 2018. That report is widely credited with significant influence on a broad range of security initiatives within the Department of Defense and civilian agencies. Bob, it's a great pleasure to have you here today. Bob is one of the most renowned attorneys in the nation and very influential on matters related to the topics we have before us today, which are cybersecurity, supply chain risk management, update on CMMC. So Bob, with that, I know you have some slides to present to us today. We welcome you and thank our audience very much for attending today. So Bob, the floor is yours.
Thank you. I appreciate the introduction. Whenever I hear, Chris, that the Deliver Uncompromised report gets credit for some of the DoD's initiatives in cyber and supply chain security, I'm reminded that the flip side of credit is blame. And it does occur to me that those of you who welcome and support the recommendations and the outcome, I'm happy to take the credit, but there were 3 authors and I'm happy to distribute the blame to them, if it were to arise. A couple of weeks ago, I did a program as part of the ComDef exercise with an Air Vice Marshal Smythe from the UK, who's head of their space program. And in preparing for that program, Katie Arrington from DoD was also on it. I got to become more familiar with the present national security space situation. I had an impression previously that it was a changing and difficult environment from a security perspective. What I hadn't appreciated was the growth and capability of Russia and China to threaten attacks of a kinetic or similar character to deny or disable our satellites. This is an area of profound importance to the operation of our national security establishment, to the fulfillment of missions small and large, as well as to our commercial economy, of course. And it's also an area where we've enjoyed, if you will, a luxury of several decades of being able to do it best with relative security approaching immunity, where highly specialized companies can spend a great deal of time and a fortune developing a small number of platforms of extraordinary capability, free from much doubt that anyone could rival them, and essentially free from much doubt that they could be challenged either by cyber attack or kinetic attack. And I should mention, over the many years that I've been doing this, for roughly 20 years, my principal client was Hughes Aircraft Company. And in the course of my work for Hughes, I had occasional glimpses into some of the extraordinary work that they did, but that was a different time. And so we have to confront a reality that has much changed. Our dependence upon space, if anything, has increased and will increase further as we move into the deployment of these proliferated commercial networks that support 5G-enabled systems. We also have to deal with a situation where adversaries have a panoply of methods, tactics, techniques, and procedures by which they could use to subvert, deny, disable, or degrade the various elements of space systems. And with that as a cheerful beginning, I will put the slides up. So I will start as we get this put together. So almost everyone who's on this call, has heard that on September 29th, the Department of Defense issued an interim rule. And that interim rule includes two elements. One is a requirement that companies, certain companies, roughly 20,000 of them, submit a self-assessment of their cyber measures using NIST Special Publication SP 800-171. Let's call that the DoD assessment component. And then the second component is a new regulation that concerns DoD's emerging cybersecurity maturity model certification, CMMC. And that rule's gotten a lot of attention for reasons that will become apparent. And it certainly is going to have a consequence to some of you, and perhaps all of you, and as well as your supply chain. The rule is both more and less than you might imagine. It's more in that it has essentially immediate consequences for companies that haven't done a good job to understand their cybersecurity posture, or who haven't planned fully to improve that posture. It is a little less than you might expect because the CMMC component, though widely advertised, if you will, actually doesn't come to take effect for more than a relatively few companies for some potentially extended period of time. This new rule is also less than you might suppose in the sense that it only deals, at least in my view, with the security for network systems. And its principal purpose is the protection of various forms of controlled unclassified information. Many of you on this call are dealing with systems that are much more complex and impactful. Some of you will have systems that include both classified and unclassified information. For many of you, the level of controls that are present for this new rule are probably not sufficient for what your customers or their mission holders would expect. And also, in my judgment at least, this rule really doesn't get very far, very well into operational technology, such as SCADA, ICS, factory systems, and the like. And it doesn't get especially far into supply chain risk management. And we're going to talk mostly about the rule and what it does and doesn't do, but I want everyone to appreciate that this is only part of the security problem, especially for the interconnected web-like nature of space systems. We do need to be thinking about OT and ICS and the like, and especially as we consider the nature of vulnerability, the vectors of threats that could be delivered against national security systems, we absolutely, totally, definitely, and seriously have to consider supply chain risks, only a few of which begin to be addressed by these new rules. Let's go 2 slides ahead. That's the one. So, you know, there's been a lot of commotion about this rule. DoD issued it as an interim rule without the usual notice and comment that precedes new rules. It made it effective on November 30th, just 2 months after the publication of the rule. And it was about 80 pages in the format that was produced the day before the Federal Register. So it's a lot to read, to have it sort of appear suddenly without any opportunity to comment in advance. Now you can comment, and maybe you should comment, and the comments are due by November 30th. But one of the things to appreciate, frankly, is why? Why did they do this as an interim rule? Why didn't they give us, the industry, the stakeholders, the affected, a chance to think about this and comment before they made it effective? Well, one of the reasons was last Tuesday, the election, and another reason is the inauguration that's going to happen or not happen next January, depending on who ends up with this. My conclusion, not based upon scientific evidence, but deduction, is that they decided to use an interim rule in order to make sure that this thing was on the ground and the obligations were present before we got to a change in administration. We all know that threat and vulnerability and consequence, that is risk, are going to remain more or less the same after the election and after the inauguration as they were the day before. But the methods that you use to respond to the risk could change for the new administration. Well, now what changes may or may not occur will be in the context of this interim rule that is already in place and getting underway. And one of the things that sort of surprises me is the number of people who seem to be shocked, surprised, amazed that we could have these new obligations. And so in this section, I'm going to briefly kind of run over the context. And the simple point is this. This purpose, namely to improve the security of the defense industrial base so that it better protect unclassified but sensitive information, has been around for a long time. It's just taken us a very long time to figure out how to get it right. So here I have an executive order from way back in 2013. Can you remember that? Seems like never, not so much yesterday. So it says that, incorporating security standards into acquisition and planning and contract administration is part of this executive order. Well, here we are, nearly 8 years subsequent, and we're finally beginning to get that accomplished. Next slide. So this one is pretty important. Hold on, I got to change my view for 1 second. This one's quite important because it shows you the long gestation of the rules that are actually being now applied. See, what we had before was a whole framework of standards and practices and purposes and policies and contract requirements, but what was missing was kind of any actual effort to hold companies to task. And what was present was a high degree of trust in whatever it was that contractors, by implication, said that they were doing just to provide adequate security. So the controls that are required here to protect controlled unclassified information are those which are stated in NIST's special publication 800-171. The initial public draft of that came out in November 2014. We're now at revision 2. 171, as won't surprise you, is largely derived from the Bible 853. It uses 14 of the 16 security families from 853. But it distills the controls into some that are called basic and some that are derived from 53. There's only 110 of them, and each one is expressed in a single sentence. Well, compare that to 853. The idea behind 171 was that this was intended not for federal information systems, but for commercial organizations, and that most organizations already would be doing most of these things, so it wouldn't be too hard. Well, it hasn't quite played out that way. Now, the next thing that happened that was important was this controlled unclassified information rule. That's the responsibility of the National Archives and Records Administration, a small part of the Department of Commerce. And essentially, it was given the task of trying to herd the roughly 100 forms of information that were unclassified but controlled, for official use only and the like. And it produced this proposed rule on CUI on May 2015. And as the rule has emerged, NARA has prepared and maintains a registry of the various groupings and categories of controlled unclassified information, which have to be protected by reason of federal statute, regulation, or government-wide policy. Well, essentially the purposes of 1 and 2 together are to have the cyber controls which the government expects you, the private contractor, will employ to protect all of these types of controlled unclassified information. Question, do you know when you have it? Sometimes, if it has a distribution statement. Do you always know that you have it? No. Do you know which types you're supposed to protect? Well, in theory, but in practice, it gets hard. So let's go on to acquisition measures. Acquisition measures actually have some importance to security and even to mission. at least in the sense that if you have a security objective and you want to make sure that your contractors achieve it, you use acquisition measures to get that done. You make it regulation that will affect, guide, or control the actions of contractors. Or you put it in a contract clause, which makes it a requirement. Or you put it in an evaluation, part of a solicitation criteria, part of the evaluation structure. So the key acquisition measure here is the safeguarding, cyber safeguarding clause, DFAR 7012. That's been around since August of 2015. And since then, it has required companies where they have this clause present in their contract to have adequate security to protect covered defense information using those 171 controls. Now, what is covered defense information? Well, it's essentially the same thing as CUI. Now, interestingly, DoD is most concerned, of course, about controlled technical information. So are you. That's information of military or space significance. But the way the rule was written, it requires you to protect not just that CTI, which is most significant in my opinion, but also all of these other categories where there's good reasons to protect the information, but it can be awfully hard to figure out where it is or whether it actually fits, the government categories. So coming late to the party, if you will, was some actions of administration and oversight. And these have occurred gradually. And if you've been paying attention to the news, you'll realize that, this new CMMC rule or interim rule shouldn't really come as a surprise. The build-up's been there. So in October 2018, Secretary Mattis established the Protection of Critical Technology Task Force. It's still operating. Its job is to essentially offer guidance within the Pentagon on how to protect the most critical technologies against the continuing exfiltration of those technologies to our adversaries, especially China. One of the things that the PCTF has been emphasizing is this proposition that if you don't protect sensitive but unclassified information, you shouldn't be doing business for the government. Now, another thing that was important that came out was guidance for assessing compliance. It actually first came out in November 2018 from Ms. Lord, the Undersecretary of Defense for Acquisition and Sustainment. That guidance incorporated a methodology that was later further elaborated for the self-assessment as well as assessment by DCMA of cyber compliance. Those methodologies are still in play. DCMA was given an important role in verifying contractor cybersecurity, and that is still in play. But here's a crucial point. DCMA is resource limited. The scale that DCMA can operate is constrained by its size. DCMA has created something called the DIBCAC, Defense Industrial Base Cybersecurity Assurance Center. It has I think under 200 people. It's done under 100 assessments. It has a method to do it and some track record of getting it done. But what DoD wants to accomplish is the protection of covered defense information for at least the 20,000 companies that are subject to this 7012 clause. And that is the purpose of the new CMMC initiative, first announced in January of last year, or first embraced by DoD, and then the new regulation. Next slide, please. I'll go through these pretty quickly because too much background is not a good thing. So I want to say to kind of understand what's in and what's out here and how we got here. Now, many of you are familiar with FIPS, Federal Information Processing Standards, and many of you are familiar with the statute that produced FIPS, which is the Federal Information Security Modernization Act. Well, a lot of this architecture that we're going to talk about today was essentially a product of FISMA being applied through FIPS and then being extended to commercial industry. What FIPS does is to talk about information and information systems. I get into arguments about this still. I had one on an NDI call yesterday. I continue to say and believe that as a matter of history, techniques, and operation, this 7012 clause and 171 and CMMC, they're all useful for protection of information and information systems. There it is. They really weren't intended to or designed for protection of OT. And they certainly aren't getting very far into the Internet of Things or 5G. And those things are really important. And we got to not assume that these methods, while useful, will cover that. And it's also crucial to appreciate, what of the triad of objectives are covered by these new DoD rules and what are less covered. from the very beginning, the principal purpose of this rule set of the 7012 clause has been the protection of information and the avoidance of the loss of confidentiality of that information. The confidentiality is lost if the information is stolen, exfiltrated, or the results of industrial espionage. So the other things that count an awful lot, and especially, if not even more so for space systems, are integrity and availability. If you think about it from a system standpoint, you may care a lot that somebody takes your design information. You will care a lot, but you're going to care an awful lot for a space system if someone is able to corrupt the integrity of the system so that it no longer produces trustworthy results, or if someone is able to infiltrate or attack the communications links or the command and control of a space system so that it's no longer available, or that you'll doubt whether it's available when you need it. Let's go to the next slide, please. Now, this is just to kind of illustrate the point I made earlier. Most of us have some idea of the types of controlled unclassified information that we want to protect, but few of us have a very precise idea of the shifting categories. NARA is a small organization. It does a great job. But, its job is to essentially collect and organize these different forms of information that are required, for which protection is required by statute, regulation, or government-wide policy. This registry that they produce changes over time. This particular chart illustrates the changes. Now, if you're a defense contractor, you're going to be pretty sure that there's a few of these things that are going to apply to you. And, they're going to be wondering about other things, whether you have them or whether they apply to you or how you're supposed to find them. That is a difficult problem still not solved. DoD has just issued some new instructions that are supposed to improve the ability of contracting officers and acquisition personnel to tell you when you have CDI. Whether those actually achieve their purpose remains to be determined. Next slide, please. Let's talk about NIST 800-171. So, as I mentioned, we've got basic and derived families. This basic safeguards track back to FIPS 200. The derived reflect 853. Now, one of the problems that we've got in this world is that, it's built upon standards and practices, and it's executed through contract clauses and requirements. But, agility would not be a word that I associate with the accomplishment of this security plan. These controls basically are the same as those that came out in 2015. And although NIST SB 853 has moved on to Rev 5, which has a substantial supply chain component, 171 really hasn't moved that far. And there is, an argument among the more technical types that while this is an interesting way to approach some aspects of security, it tends to kind of put you into, cubby holes, brackets, pockets, and, and sort of preformed places. And it encourages an approach towards security that looks to see whether you can check the box for each of these 110 controls. Compliance is very important. It's definitely a part of security. It's required by contract. But no one should be confusing compliance with security, especially in areas of such sensitivity, impact, and complexity as space systems, where, of course, you want to do 171 if it's a requirement, but you need to be thinking a little bit beyond that. Now, to its credit, when we get to this CMMC maturity model, it takes 171 as a baseline, and then it adds things. This has been the cause of some complaint. The closest approximation to the 171 is CMMC maturity level 3, and that's something that adds 20 practices and policies, some of which are harder to do, but they reflect a more, if you will, contemporary and evolved understanding of what are recommended security practices. Next slide, please. This is the key safeguarding clause. It's still with us. And what it basically says is that you have to provide adequate security, and you do that in accordance with 171. Now, what's interesting here is that when this clause was put in place, it essentially told every contractor, if I remember my dates correctly, by December 31st, 2017, again, an age ago, that you were to have these 110 controls in place. But there was nothing that said you had to send in a certification, and there was nobody going to come and check you. Essentially, this was all a self-attestation regime. And, if it had worked perfectly, had exfiltration had stopped, and the Chinese had, were no longer successful at stealing our data, well, I suppose that would have been well enough good. but it wasn't. And Secretary Mattis, was a prime instigator in realizing that, this self-attestation approach wasn't working. Now, this is where the Deliver Uncompromised report from MITRE figured in. Our sponsor was the Undersecretary of Defense for Intelligence. And, our mission was to go kind of figure out how can we achieve this idea that when we deliver a system to the U.S. military for employment, it is not already compromised by the theft of its data or operating principles. And when we looked at the situation, what we realized fundamentally was that things had to change. This reliance upon self-attestation wasn't working. And also, we came to a conclusion that seems pretty obvious now, which is that in the contemporary world, you need to give a different emphasis to security than you had historically. The way we put it in simple terms was that there were kind of three pillars for conventional program design, management, and operation: cost, schedule, and performance. What we found was that without elevating security to equal importance, that you were going to have compromises to the integrity of your system. You would find it compromised on delivery. We said that security should become a fourth pillar, and that actually seems to have been adopted broadly, although sometimes renamed. Within OSD now, they insist that security is not a fourth pillar. It is a foundation upon which the other three pillars are mounted. That's fine. I'm happy to take the name change. It works for me. But I mention this now because, if you think about making security truly a fourth pillar or a foundation, well, then you realize that it's an end-to-end proposition, that has to begin even in the requirements definition, even in the scrutiny of technology and sources before you begin design. And it certainly has to extend, throughout the entire product and system lifecycle. And if that's true generally for what we'll call ground-based systems, it's even more true and more profoundly important, I think, for space systems, at least as I understand them. Next slide, please. So as I mentioned, this is reliance upon self-attestation. And there's another peculiar thing that was present. There's so many blind spots that are in our approach to cyber. Well, the way it was set up before, and is still, is that in order to comply with 171, the company would prepare a system security plan. Good. That means you kind of assess what information you have to protect, and you look at whether you protected it according to these 110 controls. Accompanying a system security plan would be a POAM, a plan of action and milestones. Well, the basic regime essentially said, even though you have to deliver adequate security, and even though you're going to attest by taking a contract with this clause that you meet the 110 controls, we understand that you won't, because we're going to allow you to have POAMs, which essentially recognize that there are gaps in your compliance, and we're going to give you the time that you appoint to yourself to close those gaps. And so we have a system that's basically built up upon, a wide distribution of quality and system assessment and system security plans, as well as one that essentially adopts, or accommodates POAMs of, uncertain duration, without any real way to check whether those gaps are closed. One of the core features of CMMC, when and to the extent it finally is in place and effective by contract, is that CMMC doesn't allow any POAM. CMMC says that if I have 130 practices and policies that are required for maturity level 3, that's the usual one for sophisticated contractors, if you meet 129, you don't get the certificate. If you meet 127 and promise to cover the next 3, you don't get the certificate. It's one of perfect compliance. And the logic behind it, in effect, is we have been telling you to do these 110 things for up to 5 years. You have been telling us by taking contracts that you've been doing them. And if you haven't been doing them, well, you should have been doing them. And now, if there are 130 things we expect for security, we expect to have all of them done. I continue to believe that that is a noble aspiration that is not going to prove practical. And I ultimately think that it's up to the requiring activity to make risk-informed judgments if a contractor that's needed for a program does need some accommodation and yet would not be allowed to enter a contract without the required certification. Next slide, please. Next slide, please. All right, let's talk about the new interim rule. Next slide. So, this is really 2 rules rolled into one. The first, everybody thinks of it as the CMMC rule, but what it really is the DoD assessment rule with CMMC at the back end. Beginning on December 1st, new solicitations are supposed to have to come out which include two clauses, 7019, 7020. And those clauses require companies to assess their own cybersecurity against the 171 controls, using a DoD assessment methodology that was prepared by DCMA. And then you have to report your self-assessment score to the government, as we'll describe in a minute. So part one of this is the DoD assessment methodology. If there are 20,000 companies that are subject to this self-assessment, maybe 1% might be subject to a DCMA review to get a medium level of, as opposed to a low level of assurance, and maybe 20% of those might be subject to a high level assessment. But there are a couple of key features. One is that now everybody that gets that 7012 clause and is subject to the 171 requirements, everybody is going to have to do a self-assessment, which means they have to have a system security plan. They're going to have to report that self-assessment to the government. They have to do it for every system that is relevant to the performance of the contract. And they also have to tell the government the date when they expect to finish the POAM and get in compliance with all 110 controls. So soon you will be getting solicitations that say that until you have posted that information on the supplier risk management system, you can't get the contract. And for those of you that are primes, you are also going to learn that you have to flow this down and that you cannot award subcontracts to anyone who hasn't met these requirements. These requirements, the DoD assessment, they have operation in effect as soon as you have, as soon as you get a solicitation or have a contract action that includes the clauses, and that happens on December 1st. And it's important to recognize that your obligation to fulfill that self-assessment doesn't exist at the moment you bid on a contract. Sorry, the obligation exists at the moment you bid on the contract, but you have until the date or moment that the contract is awarded to make the submission. Oh, there's also CMMC. Well, you know, CMMC is a scalable enterprise. The idea there is that through this organization, a nonprofit third-party CMMC accreditation board, we're going to train legions, armies, cadres of assessors, certified third-party assessment organizations. And those assessors are going to go out across the country and internationally, and they're going to review the adequacy of cybersecurity measures using the CMMC standards at any of 5 levels. Well, I mean, that's, you know, similar to ideas that were in the Deliver on Compromise report, so I feel duty-bound to respect the core of the idea, but it's a long process. I mean, we have maybe 100 provisionally certified assessors now. So one of the things that happened in this new rule was the practical recognition that we can ask people to assess themselves against 171 because they've already had it in their contract for years. And we do have a methodology that DCMA has had out since November of 2019 for them to do that assessment with. And we can report that result of that assessment to the government using an existing information collection methodology, SPRS, which is used by contracting officers. So let's do what we can with what we have for everybody that's subject to 171. Let's get that out and make it happen. And then as to CMMC, we're going to roll that out as we have the resources to know more. And you know what's notable is that the CMMC clause only appears if a requiring activity seeks it and if its inclusion is approved by the Office of the Undersecretary of Defense for Acquisition and Sustainment. And it's expected that in fiscal 21 now, there will be just 15 prime contracts that have a CMMC requirement, each of which are expected to have 150 subcontracts with a flow down of that requirement, producing just 2,250 companies that will see a CMMC requirement applied as to them. And that's a different requirement than the self-assessment. Here's the challenge. You don't know if it's going to be you. Now, there are a couple of programs at MDA that are being looked at, and there's a couple of programs at different services. You know, and I know a lot of efforts going into figuring out who those pilot programs are. And maybe the primes have been told that they're on the lucky likely list. But, you know, if there's 2,250 companies that are going to find the CMMC clause, -7021, showing up in their subcontract solicitation and in their subcontracts, I doubt more than a small percentage of them know who they are right now. And that's something we got to deal with because it's a different set of requirements. Next slide. So are we on next slide? Okay. Let's go to the next slide. So let's talk about the assessment scores posted in SPRS. SPRS is a system that collects information from SAMs, whether you've been debarred. It collects quality information. It collects system information upon from GuideApp about whether you've had counterfeits. And one of the key purposes of SPRS is to give information to contracting officers so that they can decide whether you are responsible and should receive award of a contract. Well, now these DoD assessment scores, self-created, are going to be posted into SPRS. There's a simple form that's used. You post your net score, and you describe the system security plan architecture that's applied, and you describe the cage code of the industry that's affected, and you put in the date, just the date, not the details of when the POAM is going to be closed out. Well, I mean, that's great if you're a single enterprise with a single factory, but suppose you're an enterprise with many factories, different systems, a couple of different business units participating. Well, then it gets a little more complicated. And suppose there are cross-connected interdependent systems that you're using to perform an individual contract. Then it gets a little more complicated still. But, let's talk about the scoring. Here's something that's kind of important. It's a net score. So you start with a maximum score of 110. And if you're not presently satisfying certain of these 171 controls, well, you take a deduction. But the deduction can be more than 1 point. There's a number of the 171 controls that are considered more impactful, and they count for 5 points. And there's quite a few that are considered medium impactful, and they count for 3. So in theory, out of a maximum of 110, you could have a situation where you fail to meet 20 of the 5-point requirements, in which case you will be submitting a score of 10. And it's also entirely conceivable that you will actually come up with a negative score and have to submit that. Moreover, if you have to apply this to relevant systems and you consider a factory system to be relevant, you may find that some number of controls, particularly say those related to two-factor authentication, either can't be done or don't apply to your system. And it's unresolved now, but if you can't meet something because the system isn't of a character where the control fits, and you have to take away those points, even if you have a great factory system with terrific OT protection, you might have to submit a score of, say, 40 or 60 or 80. And that's not going to be something that makes companies be especially comfortable. Moreover, at the same time, you have to give them this POAM date. All you have to do is give them the date. But, if you're a single company with a single factory and a single IT system and you're not using a cloud service provider, well, it's going to be pretty simple. Do that self-assessment, prepare a system security plan, post your score, and give them the date when you're going to have it all done. It gets more complicated in more complicated organizations. So let's talk about what happens here. Well, what the rule says is that you have to post these scores. They have to be present in the SPRS at the time you receive a contract award subject to these new requirements. Now, interestingly, to have a current score, it has to be something that's not more than 3 years old. Well, I mean, it's not quite the same as self-attestation, but it still has a heavy trust element. Because the basic notion is, well, I'm going to do my score today, and you, government, will essentially look to that score for the next 3 years. You're not going to know what's happened to me, what's changed, what's different, whether I've been penetrated, failed to keep up. One of the things that someday we're going to have to start to talk about is, to what extent are we going to use monitoring? Are we going to expect it or require it? What are the ways in which we can make security truly dynamic and not a sort of static exercise to get over a specific jump or a specific hurdle and then kind of hold your place, until the next time you're subject to a change review. Next slide. So here it is. The DoD assessment is required. I have a little trouble seeing that slide on the main screen. So what it says now is the contracting officer has to verify that SPRS has the summary level score. And we will see that this new requirement comes into all DoD solicitations and applies to contracting actions that include new contracts, as well as, I think, material modifications, and certainly the exercise of options. Now, one thing to note is that these requirements don't go backwards. If you have an existing contract, you just perform that as is. You won't find that this clause is added to you by a contract modification. However, if you are performing as an enterprise and it has 20 existing contracts, and then you get a new contract that does have this requirement, well, you're going to be making a report about the same or many of the same systems that, that you use for performance of your existing contracts. Now, I've co-written an article. It just came out. I think it was sent around in advance, that talks about what use is going to be made of this score. Well, the rule itself doesn't say. Basically it says if you want a contract, you have to submit that self-assessment and the date you're going to close out your POAM. And in theory, you could submit a self-assessment score of 0 and a POAM closure date of, whenever, and that would be enough. But I don't think it's going to play out that way. It's going into SPRS. There's a rule change underway now, proposed rule change to SPRS, that enhances the ability of contracting officers to use SPRS for supplier risk management assessment. And the information that you submit with your cyber score is going to be there along with your guide-up results and counterfeiting and DCMA evaluations and DUNS results. So I think what we'll find is that contracting officers will look at your cyber score. And if they are given a choice between awarding a contract to a company with a score of 0, as opposed to one with a score of 110, they might decide that the one with 0 is not a responsible offeror. Don't know that for sure. But the whole reason behind this initiative is to have higher assurance that companies are in fact going to protect CUI against cyber threat. And if you go to if you go through all this trouble and submit the score and then ignore it, what are you achieving? Not as much as you should. There's also some more kind of specific ways that the scores can be used. Contracting officers have the authority to create special responsibility requirements where they tell you in advance that to be responsible, you have to have a certain score. They could also put security requirements, I think, into a performance work statement, into Schedule C. And it's also possible that you would see them appear in Section L as solicitation instructions and in Section M as evaluation criteria. So, it's technically true that you can submit any score on any date and be in compliance with the regulation, but companies should, for business purposes, think further than that. And also for policy purposes, they should do better than that. The object here isn't to have just a good enough score. It is to have a good score and to make it better, and to do so by closing out those POAMs, etc. Now, I do mention at the bottom point here that procuring activities could decide somebody's non-responsible. If that happens, we could find yet more fuel for protests. But there's also, another risk that companies should be alert to, and that you should be wary of in dealing with your subcontractors. That's the possibility that companies will figure, well, I don't like the score I'm going to submit, so I'm going to resolve all doubts in favor of a better score. And I don't want to tell them it's going to take me 5 years to close these POAMs, so I'll tell them it's a year. If you do that recklessly, in reckless disregard of your obligations, if you do that, knowing that you're providing false information, you are at risk of exposure under the False Claims Act. Now, there are not going to be too many of those suits, but they could happen. And if they do happen, whether brought by a whistleblower or by the government, I can tell you to a certainty, having defended a few of these, that whatever you thought you might have had to spend to improve your security will be a small fraction of what you're going to have to spend on lawyers and in settling the liability on an FCA case. Next slide, please. So I mentioned briefly earlier that under this new regulation, DCMA can conduct medium or high assessment levels. Basically, the regulation says we know that these self-assessments and reported scores are kind of low assurance stuff. But, we have the ability to, in the clause it says, if you take a contract with this clause, you accept that DCMA has a right to come to visit and to do either a medium or high assessment of your system to see whether you're doing what you've said you've done. And if you're going to come see you, well, you need to have documentation, meaning your system security plan, and you need to have documentation of the POAM and some actual detail as to how you're going to satisfy it. Only a small percentage of companies are going to be subject to a medium assessment. And that medium assessment involves essentially a look over your documentation. And an even smaller percentage of companies are going to be subject to high assessment, where they're actually going to test your system. They bring people to do it. Now, they're going to be looking for programs that are impactful. In other words, focusing their limited resources to do these on-site assessments for things that matter more. But it's sort of like the IRS audit. And I think this actually was their planning, although no one will admit it. Everybody submits tax returns. Some number of people are audited, just sort of at random, it seems. And the fact that somebody got audited sometime, it tends to warn you that you should be careful in submitting your taxes because you don't want to be audited. Or if you do, you want to be able to show them the documents that'll prove those business deductions, whatever. And there's a very smaller percentage that's going to be investigated, which is like, an audit on angry steroids. That's a new analogy. I'm going to keep that one. So, I think it's sort of the same thing, but it's really important because this is still, it's still a self-assessment regime as it was before. The difference is this time you got to tell the government what your assessment is. But there's that other part which says that you agree that DCMA can come and look, and you agree that they can come and investigate, if they want to. And that ought to make everybody being pretty careful to be sure that, they just don't throw a number in there, that they've actually done the stuff and documented it. Now, there are going to be situations, of course, where contractors not going to agree with the result, and there is a method provided for rebuttal and adjudication of assessment scores. I do have some insight into what DCMA experience has been. They've had a number of primes who have had high assessment who have done great, but they've had a number of smaller companies where it hasn't gone well. And there was one example in the last year where essentially the system security plan was prepared apparently a few weeks before DCMA showed up, and the outcome was not pretty. Here's another thing to appreciate. This is not just for supply contracts. This is for services contracts also. Now, DCMA only has the authority to go in and do these assessments for supply contracts, but it's seeking to get some authorization so that it could do them for services contracts as well. Very important point. If you're a solution developer, not a hardware supplier, this applies to you just as much as it does to the person who makes the platform and hardware. Next slide. Now, CMMC, of course, that's the sort of marquee event. It's there, but it's rolling out slowly. We don't have the assessors. We have these maturity level document, which is very interesting, but it's not really well understood yet what these additional policies and practices will require. And there's some wariness at this 100% satisfaction. There's 5 levels to CMMC. Level 1 applies to federal contract information, which isn't CUI. Level 5 gets into high value assets, and where you're trying to deal with APTs and the like threats. Very, very important. If your customer wants you to satisfy level 5, in my view, they've already told you that, and you're already working on it. Because those of you who are dealing with those level of threats and that kind of critical high value asset, I don't think that the government, I would hope that the government is not simply saying, well, we're okay with the 7012 clause and whatever you can get done with 171. However, this is a lot to work out. CMMC has a terrific purpose. And I think the purpose of making companies prove their compliance and their adequacy of their security is a good one. The mechanics of how it gets done, well, there's a lot of ground yet to be covered, and we could see some changes in those mechanics if and to the extent there's a new administration. Next slide. Now, the CMMC clause will show up in contracts for 15 prime contractors and 150 subcontractors. Some of those will be at maturity level 1 because they really don't have the assets yet to do it any further, but some are going to be at maturity level 3. The purpose of maturity level 2, it seems to me, is no better than sort of a buffer for those who can't quite get to 3, but are better than 1. And if it were me, I'd get rid of maturity level 2 entirely, but it's not me. So when this clause rolls out, then it's fairly profound, but that assumes that the future is going to include, this legion of assessors and a capable and functional accreditation mechanism and proper methods for dispute resolution. All that stuff remains to be built. When it's out, what it's going to tell you is that not only do you have this clause in your contract, if it says you have to have a maturity level 3 certificate, you have to have it, and you can't get the contract without it. And that's going to be a taller order because there's no tolerance, as I mentioned, to POAMs. And that's when you don't even try until the SSPs are done. I think eventually they're going to need to accommodate some situations where you'll get a limited period to close gaps that are found. And there may even need to be situations where requiring activity gets the chance to make its own decision as to whether to exclude you because you didn't quite get the certificate, or include you where they have the ability to monitor your closure of the gaps. Next slide. Now, we're getting into the stuff that's kind of outside the immediate CMMC and interim regulation. And I want to make sure that we have time for our questions, Chris. So I'll just make this very quick. Supply chain threats are different. The CMMC and the Interim Rule are basically dealing with the cyber IT threat. In the MITRE Deliver Uncompromised report and elsewhere, we recognize that there are distinct and different threat vectors. Cyber OT, which includes, I think, 5G, as well as the Internet of Things. And of course, supply chain. And supply chain has many contributing elements: hardware, software, service providers, logistics, workforce. I mean, as you start to kind of disassemble the supply chain, especially for space systems where it gets very, very complicated and global, there's almost a limitless number of points of potential vulnerability. And, we don't really have in place now regulations or contract requirements that deal very well with those. What we're seeing is the emergence of requirements that companies prepare a supply chain risk management plan that calls upon you to assess your own supply chain for business and regulatory purposes, and then to document the plan that you have to mitigate those risks. And then the concept is that you submit that plan to the government, where it's where it's going to be evaluated. It could be pass, fail, it could be scored. And then once you have the plan, essentially there'll be an obligation to perform to the plan and some opportunity as a matter of contract administration to be sure that you do. Now, if this sounds far-fetched, it's not. It has been included in new RFPs that the GSA, of all entities, has put out for Astro and STARS 3, and those are important multi-award vehicles. And there's been indications from DoD and elsewhere that similar approaches are going to be taken. But we have a long way to go. And I could make an argument, and maybe this is a good place to start our questions, Chris, that for space systems, let me go back a step. So we've talked for 45 minutes or so now about these regulations that are focused upon protection of network security, protection of information systems, and the information on those systems. All good. But, if you're a space system and the asset's already in orbit, of course, as I said, you're going to worry about somebody stealing that information such that they could replicate the design. But you're going to worry an awful lot about people delivering, say, a supply chain attack, or crippling your 5G network enablement, or compromising your communications links in order to deny you the benefit of that system. And because that, if anything, is more consequential, is more controllable, and can have much more immediate effect at an adverse time of crisis or international uncertainty. And so I think for space systems, protection of information is, of course, really important, but we got to be thinking about protection of the supply chain and protection of OT, because adversaries are not going to limit themselves to an answer of building a replica satellite and putting it in orbit, or building a particular weapons or anti-satellite system that exploits a known vulnerability. They may do that, but there's so many other ways in which they can do not just mischief, but harm, that we have to get smart about it. And we have to be thinking in terms of architecture, structure, strategy, than I think that the way things have been done before. Over to you, Chris.
Well, that's a great presentation, Bob. We really appreciate your insights. I'd like to go back to a number of the concepts and terms that you used, and see if we can do a little tutorial in some of these areas. So a little bit of this will be redundant with some of the things you said, but I think it's useful to reinforce a few key points and raise some questions. So as you noted, the interim rule that's effective in November is effective coming up in November the 30th here, requires offerers subject to NIST Special Publication 800-171 controls to have a current assessment for each covered contractor information system that's relevant to an offer or contract in order to be considered for an award. How do companies know if the interim rule applies to them, number one, and number two, how do contractors know which information systems are in fact covered and which are not? Are they informed of that, or do they have to make those determinations on their own? How does that, how is
It's
that?
really, it's the latter. So, I mean, the easy part is seeing whether you have a solicitation that includes these new clauses. 7019 is the solicitation clause for the DoD assessment, and 7020 is the contract clause. But the fact that they're in your contract or solicitation doesn't actually tell you whether they apply, because the self-assessment is only done according to the regulation if you are required to comply with NIST SP 800-171. Well, are you? How do you know? Well, there's a couple of ways in which you might know. First, do you already have contracts with that 7012 safeguarding clause? I put that up on a slide earlier. That's the one that says adequate security using the principles of 171. So, do you have this new interim regulation clause in? 2. Do you have the 7012 clause in a contract already? 3, do you have covered defense information? Because it's possible that you could have the clause there as a boilerplate flow down without actually dealing with covered defense information. And if the sum of all of those things is true, I have CDI, I have the 7012 clause, and I have the new interim regulation clause, well, then I'm going to have to do the self-assessment. Now, the next question is, how do you know which systems are covered? Well, that's hard. The language that's used is relevant to the performance of the contract. Relevant? I mean, as a lawyer, we learn that relevance means a lot of things, right? I mean, it's kind of a bell-shaped curve. If I want the evidence to be admitted, even if it has little actual relationship to the event, of course it's relevant. If I want to exclude it because it doesn't have a material bearing or could be misleading, well, then I say it's not relevant. This is going to be difficult because, look, I mean, it used to be that factory systems would be kept separate. They weren't air-gapped by design. They just weren't ever connected. Well, that was then. That's not now. I mean, we see this convergence of IT and OT. And if we see it now, with 5G enabled systems and IoT, we're going to be living in it soon. And, are those relevant? Well, maybe. What about payroll? Is that relevant? Possibly. HR, I suppose it could be. So it's going to be hard decisions, and there's really no guidance at present. Now, the facile answer to this is to say, well, I'll just deal with this all at an enterprise level. That's nice, but that's facile. And the reason it's facile is that companies are complicated, especially those of you who are going to be looking to international sources of advanced and innovative technology. You're going to be dealing with companies for whom the Department of Defense is an incidental part of their business, for whom they would really care less. And if you put too many burdens on them, they're just not going to sell to you. So, we have, it isn't easy to know what's relevant. I think what I was trying to say is that it's not going to be feasible for some companies, especially those that sell both commercially and to defense, to raise all of the enterprise to the higher level. That's what we'd like to do, but we can't always do that. So we're going to have to sort out, how to determine which system is relevant. If it's at the plant, that is responsible for the design and the development and the fabrication, or at the facility that's running the sustainment of the system, that's relevant. Beyond those boundaries, harder to determine right now.
Right. The interim rule, CMMC, requires a self-assessment by contractors with access to controlled unclassified information. Before, you mentioned the quote-unquote legion of assessors, for example. Do contractors conduct the assessments internally, that is in-house, or can they outsource such assessments? If companies are allowed to outsource such assessments, what type of information will they need to collect or generate in order to successfully complete such an assessment? And how do they identify, how would companies identify qualified outside vendors? Again, you mentioned legions of assessors. Do these companies now exist? Have they been certified? How does a company make its way through the thicket there of identifying whether to do it internally, conduct the assessment internally, or whether turning it over to an outside organization? And how do you know that that outside organization is going to do a professional job?
Well, the answers vary and they will change over time. You can do the assessment in-house. And if you have the IT capability or the information security staff, that's obviously the place to start. Many small and medium-sized companies don't have that. So going outside to consultants is necessary. Since CMMC has started to kind of roll itself first to the horizon and then closer, we've seen this huge amount of market activity. I mean, if you put the phrase or the letter CMMC into a Google search, I mean, you're going to get an awful lot of people who are promising you the best solution at the lowest cost. And it is quite difficult to know who is best. Now, the CMMC Accreditation Board has a registered practitioner program where it is doing some training to give people at least an elemental qualification that they know enough to be trusted by that organization as a practitioner. I admit that I have signed up to become a registered practitioner. I also admit that I have not had anywhere near the time to actually do it, but I have some reason to think that it's a valid program. It's going to be tough. I mean, there are different answers for different types of companies. For some companies, the best answer is going to be to look to a consultant who can move many of your functions to one or another cloud service provider. For other companies, the better answer is going to be to tighten up the controls and process and procedures, for the company itself. We also have to make a distinction between what's required. Some of it is policy. Policy doesn't require specialized consultants that live with you. It may require kind of an isolated, focused effort to understand the policies that are required, get them written up, and make sure they're subscribed to within an organization. There are also hardware elements and software elements, and those can be different. I think the smart move for many companies will be to do a discriminating look at potential consultants, ranging from small, who can be good, medium, look at their prior credentials, look at the individual credentials of the people they propose to help you, and ask to review their results, ask for references. You're going to want to get that advice up front, and you're going to want to get good advice because you can get answers that range from just the veneer that won't do the job to things that are grotesquely over complex and over expensive. But, it's going to be, you're going to be looking outside for help often because too many companies just don't have the ability internally.
Right. Can companies use or encourage their suppliers to use managed service providers or managed security service providers?
Yes, there's still some uncertainties. I think that's inevitable. Look, I work at a small law firm, and we represent some large technology clients, one of whom you mentioned, and we are expected to protect their information, as we should be. We have one guy in-house. He's very good, but he can't cover this. So we use a managed service provider who provides managed security services. And without that capability, I don't know how we could do it. Now, I don't know that a law firm is like any other sensible business that makes, that has productive value to society. But I know many small companies as well, and managed service providers definitely have a role, and managed security services do too. But, if you're going to be relying upon a third party of any type to be delivering security or assessing and assuring its continued delivery, well, you have to make sure that the provider itself is secure. And that gets into questions of what you know about the nationality of the provider, what confidence you have in the vetting of their personnel, and whether there are any reasons for concern as to the sovereignty of any of the assets that they may use to provide the services. Now, the simple answer is to say that, well, anybody who's delivering a cloud-based security service should make sure it's a FedRAMP moderate or equivalent. That would be nice, and if you can do that, that is best. But I'm not sure that is an answer of sufficient ubiquity right now, and I think it's worth considering. I hope DoD will consider some other ways to encourage managed service because, by definition, you are essentially creating entities with a high level of expertise who acquire a great deal of experience who can apply that across a broad base so that it's an affordable and successful outcome. And that's even more true to the extent you can move to the cloud where there's obviously, the scale and concentration of capabilities. These things are really not as well developed or articulated within the interim rule or the CMMC as they should be right now, in my personal view.
Right. CMMC requires vendors to perform various actions and assessments, each of which takes time and incurs costs. Are all such costs reimbursable to the government? How will this work in practice? Do companies spread the costs across multiple government contracts or charge them to a single contract? And if it's the latter, how do they know to which contract the cost should be added?
Well, it varies. If you are a DoD prime, subject to the cost accounting standards, with a cost accounting system, and if you do flexibly priced work and you have a forward pricing rate agreement, well, yes, I mean, these are reasonable and allowable costs. You would take these costs and you would put them in your overhead and you would distribute them to the cost objectives that you use to perform for the government. If, however, 40% of your business space is commercial, well, then 40% of the costs that are accumulated in overhead are going to be distributed to commercial customers, where there may be competitive constraints where you can't charge to recover those costs. The big problem is that this rule is intended not just to cover the, say, 1,600, if I remember correctly, CAS-covered contractors. This interim rule is supposed to apply to 20,000 companies. And many of those are going to be small and medium-sized companies who don't have government contract cost accounting systems, or even if they do, don't do any flexibly priced work. And so for those companies, telling them that they can put it in their overhead, it isn't a great resolution. And they may be subject to competitive constraints where even if it were in their overhead, they won't want to bid that cost. So it's a problem. Now, as far as direct charges, the compliance with the basic requirement of SB 800-171, DOD's position is you should have been doing it already, and any incremental costs that you incur are overhead, but they cannot be charged directly to any cost objective or contract period. They're probably right on that. What DOD has said, however, is that if we require you to do more, tailored security, CMMC level 4 or 5, stuff that deal with APTs and higher level threats for high value assets, that, they say, you're going to see as a contract requirement, and that can be a direct charge.
You noted that there are 5 CMMC accreditation levels. When do you expect that CMMC assessments will start, as distinct from the self-assessments you mentioned as part of 800-171 measures?
Well, I think the objective of the CMMC program office is to get some of the pilot programs up and running soon. I mentioned that the accreditation board has been training provisional assessors. And I think that the second class is being trained now. And maybe when that's over, there'll be 120 or so provisional assessors. Now, in addition to having the trained assessors, you also have to have some guidance as to what they're supposed to assess and how they won't have the regularity you need to make this a viable system. We still have not seen the assessment guide. It's been in the works or in contention between the AB and the PMO for quite a while. Got to have that, because the assessment guide essentially is what's going to tell the company how they're going to be assessed, and it's going to tell the assessors what they're supposed to assess and how. In the FedRev counterpart, the assessment guides are just crucial. I mean, that's what tell you what you got to prepare for. We don't have that yet. Now, that said, I think we're going to see the clause come out beginning after December 1st for initial contracts. Maybe MDA will be one of the first ones. And I think we will see assessments. Initially, I think they're going to be at CMMC level 1, which is sort of like, a bicycle with, what's the right, the stability tires, driving a low-powered car in a parking lot. I'm for once searching for analogies, but I think we'll see the initial ones come out at a low level, which is smart. But I do think that we're going to see some CMMC level 3 assessments that are conducted during 2021, and we should, because there's an awful lot being built on the premise that this is a workable solution that produces a result of sufficient value to companies and the government to justify its cost and administrative burden. We need to find out if that's true. And we also have to do lessons learned. Remember that phrase, test, analyze, and fix? This is the test, analyze, and fix.
Right. The reason behind CMMC and other cyber and supply chain initiatives is obviously the concern that America's adversaries are stealing important information from DoD contractors and using the information to accelerate development of their own military systems, including space systems, or develop counters to US systems, as you noted. Has DoD taken special measures to alert contractors of sensitive systems when stricter controls are necessary?
Yes, and more are to come. Look, there's the white world and the black world, unclassified and classified, and then there's the sort of gray, which is between the two. All of the CMMC and DoD assessment is written for the white world. But actually, there are companies who do classified work who also do unclassified work. And there are some companies who are capable of doing classified work that do highly sensitive unclassified work. DoD and the civilian agencies are paying attention to high value assets. The Protection of Critical Technology Task Force is absolutely paying close attention to critical technologies, which if stolen would harm US national security. They've developed a list of the technologies they want to protect. My expectation, but I'm not going to refer to any actual programs, is that, for programs that are highly impactful, for national security space programs, for things that benefit different aspects of the intelligence community, yes, I'll say it more positively. Yes, I am certain that on programs of the elevated character that I described, there are special measures being taken. And that makes sense. Some of you are familiar with 837, the risk management framework. And when you go to large and complex programs, security it may look to controls and expect you to accomplish them, but there's this idea that you want to make risk-informed decisions about, what is sufficient, where is the investment worthwhile? And sometimes you need to be looking outside the control landscape and considering, the impacts of particular vulnerabilities and what consequences of an attack would have the most adverse result to your ability to fulfill a mission. This certainly applies to space systems. And so there is a theory that, emerges that instead of going from left to right, building from control 1 to control 2 to control 3, that you essentially look at the enterprise the program or the mission level and say, what do I have to protect that's most important to make sure that I can fulfill my mission or recover? And that's different. And I believe that such requirements are beginning to surface and certainly are present in the planning process within DoD.
We have a question from one of our viewers who asks, how does a contractor deal with a supplier that's selling commercial off-the-shelf items? That supplier is not itself a government contractor. So how does the contractor itself deal with COTS items?
I'm very glad that question was asked because it was an omission in my presentation that I didn't address it earlier. Pure COTS are excluded, period. These things don't apply. Commercial items and services are not excluded. Now, if you go into the FAR, what it tells you is COTS are stuff that are made and available to the general public, and a commercial item can be COTS stuff that you specially configure or adapt or modify. Commercial work is included, COTS or not, and this is it's difficult because from supply chain risk perspective, there's no absolute reason to believe that any COTS supplier couldn't be compromised. But there are some reasons to make the judgment that we're not going to apply this to COTS. One is that almost by definition, a COTS supplier is someone whose products or services are sold all over the place to everybody, not just to the US government, much less the Department of Defense. And so, the DoD doesn't really have market leverage to impose these obligations upon COTS suppliers. And if it attempted to do so, it would be cutting off a limb to, spite a sprained ankle, another attempted analogy that has arguably failed. We need COTS, especially as we're moving into areas of more agile acquisition, where we're trying to be more resourceful, innovative, and faster. We don't want to cut ourselves off from COTS. So essentially, we're building an assumption that national or international companies who are providers of COTS supplies have a business interest in the integrity and security of their products that is very much analogous to our interest in the security of them from, a cyber or supply chain standpoint. So that symmetry of interest, theirs being commercially motivated, ours being maybe threat motivated, is considered, I think, close enough that, we'll take COTS without imposing these risks or driving COTS suppliers out of the marketplace for DoD.
You mentioned agile acquisition and other matters. There's a new focus, obviously, on agile acquisition and use of digital engineering to provide faster response to adversary developments and abbreviate the time required between recognition of new technology and its deployment. How do the principles and practices of CMC get applied to the opportunities presented by emerging digital engineering initiatives? And
that's a really crucial question.
A couple of follow-ups after that, Bob.
Sorry?
I have a couple of follow-up questions.
Okay, sure. So, there's a number of blind spots that are present here. The CMMC requirement as it evolves and this new DoD assessment requirement, they apply to traditional government contracts that have FAR and DFARS clauses. But everybody on this call, I think, knows already that the government is making a massive effort to use other means to conduct acquisitions and to design and develop new systems. And those other means include non-contractual instruments, other transaction. It's not clear the extent to which these DFARS clauses will apply to OT transactions. Also, we've got a problem. And to the extent that we want small and innovative companies, non-traditional suppliers, to be the source, of agility, high responsiveness, to more rapidly enable, demonstrate, and deploy technology, we're going to be asking. We want the participation of companies who are really not so well prepared to fulfill these cyber requirements. And yet, they will become, if anything, the most attractive target for our adversaries. So, this is an area that just has got to be resolved. And I hope that in the new administration, whoever leads it, we find ways, find strategies so that we can at once embrace innovative, non-traditional suppliers, and yet do so in a way that doesn't encumber them with, process or control requirements that they would find unacceptable or unaffordable. Some of the issue is money. Now, taking a kind of broader perspective on the same issue, if we think about agile acquisition or digital engineering in the context of space systems, what we're looking at are not only new sources of technologies, but new technologies that often have a global origin and are from multinational firms. Digital engineering is something that a number of global companies are investing hugely in. And obviously, Will Roper over at the Air Force thinks that this is a great concept, as he supposedly has generated a flying prototype of a 6th generation air dominance fighter in a matter of months. I mean, the promise is wonderful, but this is a supply chain that presents characteristics and vulnerabilities unlike anything we have ever seen. There are more vulnerabilities, less certainty of participants. Contrast the digital engineering approach to a space system to what was, say, employed for famous legacy systems like the KH-11. Those things are small, controlled supply chains, highly secure suppliers, complete opaqueness to the public, very long times of gestation, no interest in the best technology, much interest in the most stable, secure, and protected technology, and complete indifference to whether an adversary could mimic the system and complete confidence that they could not attack it. None of those things are true anymore. Now, and if you want to have proliferated systems, if you want to use obfuscation to get your space systems in place, if you want to have, disaggregation, same thing, I guess. If you want to have a faster cycle of exploiting better technology with an understanding that it won't last for a decade, that it may need to be succeeded within a matter of years. And all of those things have such profound consequences to who's going to participate and what you're going to buy from them and where they're going to source that stuff. That's why I said earlier that some of it is about protection of the critical information, but I think more of it is about protection of the supply chain. And it's not a matter of absolute. There is no counterpart standard to 171 for supply chain. There are some best practices and standards that are useful, but it's going to have to be a kind of context-driven, tailored approach, but one that should be of great importance to every participant, whether you're buyer, operator, user, or supplier.
And Bob, can you talk a little bit about what our friends and allies may be doing along these lines? Is anything equivalent to CMMC or NIST 800-171 in
Well, yeah.
UK, in France, in Germany, Japan? How do
So,
our friends and allies view this problem?
we've had a tendency, let's talk about it from two directions. First, to what extent does CMMC or this DoD assessment work for our allies? Not especially well. So one of the notions of CMMC is that you're going to have a US assessor who might go over to a foreign supplier or a foreign affiliate of a US supplier and go into their plant and do this assessment. Well, that generally conflicts with national laws or sovereignty principles. So DoD is going to have to work out ways by intergovernmental agreement so that some form of reciprocity can be granted in order for CMMC to work with foreign suppliers. That's a must. But let's talk about space systems distinctly. It's not. This is no longer the time when the U.S. could do things that were amazing and incapable of duplication, and everyone else would guess or view with wonder. I don't think that's the case. Maybe in some areas, but not in others. So we've seen emerge, of course, the EU as a formidable source of space technology. And the EU, in its own way, relies upon space-based systems for both commercial and defense purposes. And they are very much alert to the same kinds of cyber and security challenges that we're discussing here. Now, if you think forward into a new administration and a new approach to security, you might expect that we're going to see greater reliance and cooperation with our allies. The threat actors are essentially the same against the alliance as they are against us individually. The threat vectors are the same, and the threat harms are the same or similar. So what I expect we will see is, or what I hope we will see rather, is an effort that recognizes that as an alliance, NATO, or among partnering, the Five Eyes and NATO, I think we need to take measures that are coordinated in order to protect the information against adversary exfiltration, and certainly to understand and act in a coherent and cohesive fashion to defend the supply chain. And it goes even beyond that. I mean, this is getting outside my area. We need to be thinking about survivability and resilience of both the commercial and the military systems. And I think it's best to do this on a coordinated or alliance basis, because we're not going to be building or using our national security space systems only for the United States as if our allies didn't matter. That is not correct, in my view.
Right. We're going to go from broad policy, international affairs questions to a narrow legal question here. As our time is just about to wind up, we have two questions left. So the first is on supply chain security. Some have asserted that contract privity concerns prevent or inhibit prime contractors from understanding the lower tiers of their supply chains. Is that an accurate understanding of contracts law or acquisition regulations? And how's the issue of contract privity typically addressed in practice by DIB companies and government sponsors?
That's a hugely important question. I'm sort of amused. You didn't mention it, although you know it. I've done several years of work as a consultant to MITRE, and that work has been for federal sponsors, and this has been a subject that's come my way. Yeah, privity counts. I mean, the basic rule of privity says that I, the government, have only one neck to squeeze, and that's the person who I have the contract with. So, Chris, if you're my prime contractor and you have 10 subcontractors working for you, and each of those have 10 subcontractors or vendors working for them, I really only have access to or contractual control over you. Now, maybe if I have other regulations that reach some of your suppliers, I might know a little more. Privity is a big problem, and also a big problem that's related is access to information. In order for the government to get information about companies that is from companies, it has to actually satisfy something called the the PRA, just forgetting the name of the act, even though I've written several articles about it. There's an information collection requirement. You have to go to get to OMB and its OIRA unit to get Public Records Act. You have to get approval to collect information. In fact, just to get those self-assessment reports required OMB's approval of the records collection of the self-assessment reports. Well, this is significant in the following respect. DoD would very much like to know more about the composition of the supply chain for defense systems as well as space systems. In order for it to ask for information about the supply chain, if it's asking for anything different than what it already has a right to get, it would have to get this regulatory approval. And even then, it's difficult for DoD to force its suppliers to disclose information about their supply chains, which the suppliers don't have themselves. You know, if you're Lockheed Martin 2 or 3 levels below the prime, you're going to be uncertain, or 4 or 5 levels, you're really not going to know. And this is a serious problem. And what it has led to is an interest in or reliance upon what are called supply chain illumination techniques. These are essentially data gathering, information assessment methods that collect information from public or gray sources about suppliers and essentially give you algorithmic driven predictions of the reliability or the change in circumstance or the quality or the record or the integrity of suppliers. But it's essentially a circumstantial look. So my own view has been that DoD ought to make further efforts to improve its information collection rights. And if DoD asks companies to disclose their supply chain, in theory, companies could ask their suppliers to make similar disclosures. Like so many ideas from lawyers, these things are easier to accomplish in theory than in practice because there's a lot of proprietary information present. And even the best, the most capable, trusted prime contractors are often rather reluctant to be sharing information with anyone about who they choose for their subs. But we're going to need to go there, because otherwise, there's only so much you can accomplish with the prime, and privity doesn't give you any enforcement mechanism against anybody other than the party that you have a contract with.
Right. This is our last question because we're just about out of time. Companies are no doubt looking for additional resources on these important topics. It's a fast-moving train, as you have suggested. Where should companies go to get up-to-date, accurate information on topics such as CMMC or cyber and supply chain security, advisories, et cetera, et cetera? What do you recommend?
Well, that's a hard question. It's a good question and a hard question. It's way too hard now to get current information. Ms. Katie Arrington, who's accomplished huge things in her job as the shepherd and inspiration driver of CMMC, she tells you a lot if you happen to be listening to the next program that she's speaking at. And there are meetings that are held periodically between the defense industry representatives and the involved DoD units, and they tell you a lot. I go to those, but typically maybe 30 people do. I mean, there is no general systematic way for people to be kept current. And this is a big problem because, almost every day somebody is coming up with a new issue or new information about how to do it, what works and what doesn't. DoD needs to create a platform where people can get that information much more rapidly. Now, they did just update their frequently asked questions for cyber, and that's on the defense pricing and contracting site, and that's very helpful. And there is information that comes out from the CMMC accreditation board. But I mean, and also, there's now roughly 50 comments that are filed and available for public view on the interim rule. That's helpful. But unfortunately, a lot of the best information, would require essentially skimming LinkedIn, on a daily basis and hoping you got the right people. It's frustrating because knowledge is needed by a lot of people for reasons that affect their business and their finances and their opportunity, and it's hard to get. And the distribution of that information is more episodic or accidental than systematic and trustworthy.
Right. Well, we're out of time, Bob. Thank you so much for your time today. We appreciate your expertise in these matters, and I look forward to continuing the dialogue with you. Thank you to our audience for your participation, and look forward to seeing you on future episodes of NSSA Space Time. We do have an event coming up this coming Tuesday, the 17th at 11 a.m. Lieutenant General Kevin McLaughlin, U.S. Air Force retired, is going to be giving a presentation on a paper that will be published later this week on space warfighting culture and what that means for the U.S. Space Force. So we look forward to seeing Kevin next week. I'm pleased to be doing the interview with him, and look forward to seeing you then. Again, Bob, thank you, and thanks to all of our participants. Have a great day. We appreciate your time.
Thank you.